Good morning friends, Namaskar, Sasyakal and Adab. This is my 240th video and it covers the pleadings to be done under resumption notices. These videos specifically have been made because there have been a lot of resumption notices issues on cantonments and OGBs and leasehold bungalows. And I presume in coming days, especially the leasehold bungalows or the dilapidated bungalows, will be issued resumption notices by the ministry or by the defense estate officer. Nowadays, unfortunately, it is the defense estate staff either also getting very active. I don't know what feather they get into their cap. Some years back, we used to understand that the army was more required. So now, friends, I will be discussing a very important resumption policy which was tabled in the LOK-SABHA and it was tendered in my court case as Exhibit P2102 by my father in 1979-80. But unfortunately, at that time, the advocate who was submissioning my father's case was actually looking for ownership. He pleaded House Accommodation Act, he pleaded a lot of acts, but he did not implement those pleadings because he was not aware of these constitutional laws which are special laws for the cantonment. This policy was bought by the department and tendered by my father. It was a question asked in the Lok Sabha, question number 3553, dated 16th March 1970, answered. Now what does this say? Now SHRI BHUSHAN, will the Minister of Defence be pleased to state this policy in respect to government properties in possession of civilians in the cantonment area in view of government policy of taking steps in regard to control of urban properties. Now I would submit, I object to in respect to government properties. No, we are not government properties. How dare the government presumes, ever since we've been hackled to Article 246 that we are government lands. Be the steps proposed by the government to be taken in view of the the answer by Minister of Defence Sardar Swaran Singh. What does he say? A and B. The broad policy proposed to be followed in respect of administration of defence lands, help for builders, sites and cantonments indicate. As regard to rent control and protection from eviction, it is the policy of the government to extend to the cantonment area as far as possible the law of force in the state in question. No further special steps are considered necessary in matters to control urban properties in cantonment, since general laws designated or which may be enacted extend to the so and so. Now this is a policy. Now old grant and other holdings which provide for resumption, that the old grant holding and other holdings held on resumable tenure or portion thereof will continue to be resumed for specific defense purpose or any other public purpose. They could also be resumed when the bungalows are in dilapidated conditions like bungalow number 4 and 45 of Jalandhar, or in possession of the defense estate officer like a bungalow in Pune which I made the Janam Patri. So these bungalows are more easily targeted, that in respect of holdings which are not required for defense purposes or any other public purpose and are accordingly not desired to be resumed as provided in the proceedings clause, the earliest available opportunity, such as an occasion of request of the holder for changes of purpose subdivision as persons of sites reconstruction. So look at these are the breaches of the grant, etc., would be availed of to convert an area equivalently approximately to 3 times the authorized construction area into leaseholds in standard format of Schedule 8. The lease will be granted only if the holder voluntarily surrenders the area in excess 3 times the authorized construction, including the unauthorized construction where a lease is desired solely for residential purpose. The normal rent but no premium will be charged for the lease. Why no premium? I'll tell you why. More than 3 times the area authorized construction, whichever, it's very important, whichever, wherever, however, leases is desired wholly or partially for commercial purpose, the normal premium and rent would be charged. Likewise, where the area covered by the lease exceeds half an area, though the same be not more than 3 times the authorized construction area, the normal rent and projected will be charged for area in excess of half an acres. So this policy clearly reads how conversions of old grants into leases is to be done. Voluntarily you can surrender your surplus land or the vacant land and keep back the 3 parts of the constructed land. Let's say if my house is built on, it has an area of 5,000 square feet. So 15,000 square feet added and I can retain 20,000 square feet of area. Balance is given to the ministry. So I'll be converted into a residential lease. If I want to go into a commercial lease, I'll be converted there too. That the land resumed in accordance with the 2 preceding clause 1 and 2 will be embarked for defense requirements, where however the same is not likely to be required for defense purpose or other public purpose or considered suitable for such purposes, the same will be disposed in the manner. Where was the disposal written? I had talked in the earlier when surplus land is there, how disposal takes place. That payment for any unauthorized construction standing on the land resumed will be made according to the terms of the grant. Now here he talks it will be done on the terms of the grant. Why doesn't he talk it will be done in the terms of the Land Acquisition Act? See, these are the travesties. Where is the grant? There is no grant. But when it comes to compensation of the built up, it goes under the grant. So guys, please understand, leases not containing resumption provisions. Which are these leases? Very important. Here this policy is speaking, and I'll be talking in my coming videos, that existing leases sites non-resumable term would be continued on the existing terms, duration, the tenure. But people are not willing to understand. They don't want to, get relief. They only are looking for green pasturing. Somebody from some cantonment called me up some days back. He says, Ronnie ji, I do charity. And I've done a research. I've never seen any of his videos. I've never seen any of his research work. Never ever I've seen that man. He's from some Dehu or Kirki road, I don't know where. But what are these people doing? They wake up, they become activists, and there was a lady in Kirki, I think in 2004-05, she did a lot of mass issues of unauthorized servants and 4th class employees living in cantonments. So you gather such people, and what happens is when you gather such people, you have an en masse. You can gather 20,000, 10,000 people. But believe me, if a person like me has to gather bungalow owners, 2012 I could not gather more than 600 to 700 bungalow owners. Today I may not be able to do 60 also. So that's the problem. So existing leasehold sites on non-resumal term would be continued on the existing term duration, the tenure of the lease, and fresh lease granted after on the normal terms unless the site or property is required for defense purposes. Where in the event of refusal to renewal of lease, the construction vests in government ex parte compensation equal to 50% of the value, authorized construction will be paid to the holder. So government is actually, trying to hit us from the back. All these leasehold bungalow owners who've been getting these exorbitant rental or lease money notices. Now this policy, which was tabled 15th June 1978, that the policy for resumption of bungalows built on old grant, system of resumption of bungalows tend to give an impression of being discriminatory. Government further desires that resumption of bungalows should be done carefully and in a planned manner in such a way that the owner may not feel aggrieved or discriminated against, in that while one bungalow is being resumed, the other in the same locality or in the vicinity is left out. In order to obviate this lacuna and to create an impression of being fair to one and all, government has laid down the procedures as followed respectively. So such an important para in this, which was tabled in the LOK-SABHA on a question. Now, cases of sites held on old grant or cantonment code leases building which are on hire, the MES or the Rape Act or the 1801, 8 or 33 requisition of lands have been done. Okay, that as a case came to me, I remember from Bareilly, that the property was requisitioned and then it was de-requisitioned by the DC, because a lot of properties in 1965 war and 71 war were requisitioned. Specific defense purpose cases for resumptions will be taken up by the authorities. This will also be generally taken up zone wise, station wise, and then the proposed utilization will be sent. Okay. Now, held on cantonments, old grants and cantonment code leases, that when required for specific army projects, words, cases will be progressed by the army headquarters as far as possible. These cases will be taken again on zone wise, programmed for the utilization of the entire cantonment. In such cases, bungalows should be resumed in a compact block. Jhansi consultant, listen to this. Compact block is for bungalow number 4 in a compact block, and it should not be in an isolated pocket, and the proposal for resumption should invariably block wise, whether the isolation factor has been removed. So, and the project which has to be implemented after resumption, it should be a time bound program. So you can't just come up and say, okay, fine, we need your bungalow, and what are we going to do of it? We don't know. Whether the Ministry of Finance will approve the project on it, whether the funds will be allocated, we don't know. So these all could be pleaded by any bungalow owner in his resumption cases. Now he comes where cases are involving the violation of old grants or cantonment code lease terms. What are those violations? That each case will be progressed by the DESC authorities on a station wise basis, and resumption will generally be progressed on that basis unless there are compelling legal or administrative grounds when any such site is pictured for any specific defense purpose resumption. So here also he says, okay, fine, if there is a breach, you can't just go and say, okay, fine, we are resuming it tomorrow morning. Plan. Now, cases where there is dilapidated buildings, vacant size as per para F, in respect to proposals here, again the DLNC will be the authority who will approve this, and each bungalow which is to be taken has to be approved by the Ministry of Defence, Finance for a project. Proposals will go to the headquarters. So all this was there, but who was adhering? Did the Director General Lands adhere to this? No. Did the Ministry of Defence adhere to this? No. Did the station commander adhere? No. Did we plead in the court? No. So the court did not give us relief. So you can't blame anybody for your uneducation. You can't blame that your ignorance could be a benefit to you for law. The law is very clear. You plead, get an issue made, get evidence led. So Quartermaster General Mr. Grewal, I remember I have this original letter, because of my father, but In my case, the High Court refused to give me the proviso of filing additional evidence. Why? Because it knew that if my case goes to Sessions Court, I'll save my bungalow. Guys, for the last 12-11 years now, I'm not letting the Ministry of Defence Army use my bungalow through the court's orders now. You compensate me, use it. You don't compensate me, don't use it. I gave the same offer to the Landor bungalow owner also, Woolsburn. But that lady was living in Australia. I said, we can actually, today that house has been converted into an army inspection bungalow, and army officers go and have their vacations there. 5 or 4 course-mates of mine have gone and stayed there on a meager amount of money of 30 rupees per day. Just imagine, yaar, you throw out a bungalow owner from their house. These ladies were thrown out. I pity to the situation in the system. Is this the specific defense purpose, that you convert that bungalow into an inspection bungalow or an army recreation club? Shame on the army, you know. And then it is a shame on we consultants either, or advocates or legal luminaries sitting in these cantonments. No knowledge, but we are the best. You know, we consider ourselves, we are this. Why? Because we are masters of these civil laws, or the laws which we read when we did our law. I didn't read when I was doing my law these laws at all, Cantonment or Rape Act or House Accommodation Act or Governor General orders. Nothing was given to us. Constitution was there, but where? Whether the Government of India Act 1833, Charter Act, you know, the entire period of British was not taught to us in the law. And there where these laws were actually, this is where these laws came from. So we need to know those basic laws, and we don't know them. What do we do then? That is why, you know, somebody would just get up tomorrow morning after doing a little work here and there, reading some 7-8 books, and he'll say, I am a consultant, I can save you. I bet he cannot. It's not very easy. I please request these foolish people who write on YouTube, Mr. Das, how many cases you won? Stop doing all this. This gives you nothing. You're trying to, you know, kill your own desire. You're trying to make fun of me. What difference does it make, yaar, if your bungalow goes? It makes no difference to me. What happened with me in 2003 to 8, I do not want it should happen with you. That is why I am working hard on this subject. That is why I devote my time on this. So this policy of resumption 73150 is very important. Very, very important. My videos will be continuing like this. Thank you. Good day.